Good afternoon, my name is Sam Lewis and I'm a member of the Intellectual Property Law team here at Baker Love Lawyers. An opposition to a trademark is a formal objection to that trademark being registered. Parties may choose to oppose a trademark being registered for a variety of different reasons. For example, they may believe a trademark which has been accepted after examination is too similar to their own, or they may own a registered trademark which another party is attempting to remove from the register. Once a trademark application has been accepted, it will be published in the official journal for opposition. This commences a 2-month period for another person or company to file a notice of intention to oppose the registration of that trademark. If an opponent files a notice of intention to oppose, that party then has 1 month from the day the notice was filed to file a statement of grounds and particulars relating to their opposition. In all cases, the statement of grounds and particulars must set out the name and contact details of the opponent, the number of the trademark to be opposed, one or more grounds of opposition pursuant to the Trademarks Act, the facts and circumstances forming the basis for each ground of opposition. When the trademark applicant receives a statement of grounds and particulars from the opponent, they then have 1 month to file their notice of intention to defend the opposition. If this notice is not filed within a timely manner, the opposition will be successful and the trademark will be rejected. Once a notice of intention to defend has been filed, the opponent has then 3 months from the day the notice is served to file its evidence in support. Finally, the trademark applicant then has a further 3 months to file any evidence in reply, and the opponent another 2 months to file the evidence on which it tends to rely. When both parties' evidence has been filed, the parties will be given an opportunity to be heard. This may be done by one or both parties requesting a hearing in person. A hearing officer will be allocated to the opposition and a hearing date for the opposition will be set. Both parties will file a summary of written submissions with the Trademark Office before the hearing. The opponent must file a summary of written submissions 10 business days before their hearing. The trademark applicant must file a summary of written submissions 5 business days before the hearing. The parties will then attend the hearing and make oral submissions in support of their case. Parties may elect for the opposition to proceed on the papers. This means that the parties are given deadlines to file their written submissions as to why the opposition should be upheld or rejected. The hearing officer will then determine the opposition based on the evidence filed and the written submissions. The hearing officer will issue a decision including reasons for the decision within approximately 3 months from the date of the hearing. The opposition may be successful and the trademark will be rejected. The opponent then only needs to establish 1 ground of opposition to succeed. Alternatively, the opposition will be unsuccessful and the trademark will proceed to registration. The decision made by the hearing officer can then be appealed to the Federal Court of Australia if necessary. A notice of appeal must be filed with the Federal Court within 21 days. If you wish to file a trademark application or you've received a notice of intention to oppose your trademarks, please call me, Sam Lewis, at Baker Love Lawyers.